to the deep dive. Today, we're plunging into a really significant piece of legislation, ERISA.
Right, the Employee Retirement Income Security Act of 1974.
Exactly. It's basically the cornerstone of employee benefits law for the private sector in the U.S.
It really is.
And for our listeners maybe tuning in from other parts of the world while ERISA is U.S.-specific, understanding it gives some great insight into how a major economy tries to protect its workforce's benefit.
That's a good point. Our mission today is really just to provide a clear, sort of easy-to-grasp overview of ERISA, focusing on those core protections it offers.
And we're drawing on excerpts from ERISA Explained, Decoding Employee Benefits and Retirement Regulations in the eCFR.pdf, is that right?
That's the one, trying to distill the key stuff. At its heart, ERISA is about making sure American companies offering benefits like pensions or health insurance follow certain fundamental standards. Safeguards, really.
Okay, so safeguards. What kind of requirements does it actually impose?
Well, first off, transparency. It mandates that participants get clear, regular info about their plan, what it offers, how it's funded.
Got it. Transparency. What else?
Then there are what's called fiduciary responsibilities. These apply to the people managing the plan's assets.
Fiduciary. Like a legal duty.
Exactly. A legal obligation to act solely in the best interests of the plan participants. It's a big deal.
Okay. Anything else, Major?
Yeah. Plans also need a fair process for grievances and appeals. If someone thinks they didn't get the benefits they were due.
Makes sense. A way to challenge decisions.
Right. And importantly, it gives participants legal avenues. They can sue for benefits they're owed, or if they think there's been mismanagement by those fiduciaries.
No, it's probably worth clarifying what ERISA doesn't usually cover, too.
Definitely. It generally doesn't apply to plans from governmental bodies, federal, state, local, or plans from churches for their employees.
Okay, so government and church plans are typically out.
Right. And it also usually excludes plans that only cover things like workers' comp, unemployment benefits, or those state-mandated disability programs.
That's a useful distinction. So ERISA sets the floor, not the ceiling.
Exactly. It lays down minimum standards. Employers are absolutely free to offer benefits that are much more generous.
Which can be a competitive advantage, I imagine.
For sure. Attracting talent.
And if someone, say a plan administrator or a lawyer, needs the absolute precise legal text, the source is the Electronic Code of Federal Regulations, the eCFR.
Absolutely. The eCFR is the official, constantly updated version of these rules, maintained by the U.S. government. If you need the definitive word, that's where you go.
Keeps everyone on the same page.
Reduces misunderstandings, yeah.
So how would someone actually find the ERISA stuff in the eCFR? It sounds like a huge collection of regulations.
It is pretty vast. You'd go to Title 29, which covers labor regulations.
Okay, Title 29.
Then within that, Subtitle B, which is regulations relating to labor. And finally, Chapter XE5. That chapter is specifically for the Employee Benefit Security Administration, EBSA.
EBSA, that's the agency within the Department of Labor.
Exactly. Chapter XEV runs from Part 2500 through 2599.
Yeah.
That's the main home for ERISA regulations in the rulebook.
Title 29, Subtitle B, Chapter XE5, Parts 2500 to 2599. Got it. Good roadmap.
Yeah.
And you mentioned it's broken down further into subchapters.
Yes, it is.
Yeah.
Chapter XEV is organized into subchapters, each tackling a different piece of ERISA. Makes it a bit more manageable.
Like what?
Well, Subchapter A is general stuff, interpretations. Subchapter B has definitions, who's covered. Subchapter C is all about reporting and disclosure, what plans have to file and tell people.
Okay.
Subchapter D gets into minimum standards, especially for pension plans. Subchapter F details those fiduciary responsibilities we mentioned.
Right, the acting in best interests part.
Yep. Then Subchapter G covers administration and enforcement, including penalties. And there are others for more specific things, like group health plans.
That structure seems helpful. Let's maybe zoom in on one type, employee welfare benefit plans. What exactly falls under that umbrella according to ERISA?
Okay, yeah. The main regulations for these are in 29 CFR, Part 2510 for definitions, and Part 2520 for the reporting and disclosure rules.
So how does Part 2510, specifically Section 2510.31, define a welfare plan? What kind of benefits are we talking about?
It's pretty broad, actually. It includes plans providing medical, surgical, or hospital care. Also benefits for sickness, accident, disability, death.
So health and life insurance type stuff.
Yes, and more. Things like vacation benefits, apprenticeship or training programs, daycare centers, scholarship funds, prepaid legal services, even holiday pay, severance pay, and similar benefits can fall under this.
Wow, that covers a lot. Are there things that seem like benefits but are explicitly excluded?
Yes, good question. Some things are carved out, like Regular compensation practices, overtime pay, shift premiums, holiday premiums aren't welfare plans.
Okay, just part of pay.
Right. Also, if an employer just pays your normal salary from their general funds while you're out sick or on vacation, that's usually not an ERISA welfare plan either.
Ah, so it often depends on whether a separate fund or formal plan exists.
That's often the key distinction, yes. And there are also specific rules for excluding certain voluntary group insurance programs where the employer's role is really minimal.
Okay, so assuming a plan is a welfare plan, what are the basic reporting and disclosure duties? What does the employer have to do?
The fundamental rule, laid out in Section 2520.1011, is twofold. Plan administrators have to report certain plan info to the Secretary of Labor.
The head of the Department of Labor.
Correct. And they also have to disclose important details to the people covered by the plan, the participants, and beneficiaries. It's all about transparency.
Making sure people know what they've got.
Exactly.
Are there any breaks from these rules for, say, very small companies or certain plan types?
Yes, ERISA does provide some exemptions. It recognizes smaller plans might not have the resources for extensive administration.
Like what kind of exemptions?
Well, there are simplified reporting options or exemptions from certain requirements for small welfare plans, generally those with fewer than 100 participants. Also for some types of group insurance arrangements, apprenticeship and training plans,
Okay.
and for plans that only cover a select group of management or highly compensated employees. These exemptions are detailed in sections like Sections 2520.104, 20, -21, -22, and -24.
So it's not strictly one size fits all.
Not entirely, but even with exemptions, there's usually still a basic duty to file some info with the Labor Department and provide key documents if participants or the department asks for them. That's covered in sections like Section 2520.104A1 and Section 2520.1048.
Got it. And what are the really crucial documents that participants should expect to receive or be able to get for a welfare plan?
Two key ones stand out: the Summary Plan Description, or SPD, and the Summary Annual Report, the SAR.
SPD and SAR, what's the difference?
The SPD, covered in Section 2520.104B2, is really the main user guide for participants. It has to explain the plan's features, benefits, eligibility rules, how to make a claim, participant rights, all in understandable language.
The go-to document.
Definitely. The SAR, under Section 2520.104B10, is more of a financial snapshot. It summarizes the plan's financial activities for the year based on the annual report filed with the government. It gives participants a high-level view of the plan's financial health.
And you mentioned electronic disclosure earlier. Are these often sent electronically now?
Yes, very common. And there are specific rules for that in Section 2520.104B31. We can dig into those details a bit more when we circle back to reporting and disclosure overall.
Sounds good. Okay, let's shift gears to the other major category. Employee pension benefit plans. How are these defined under ERISA?
Right, so pension plans, the definition is in 29 CFR Section 2510.32. Essentially, these are plans designed to provide retirement income or plans that result in income being deferred until employment ends or even later. Focus is squarely on retirement.
So this covers the classic pensions, the defined benefit plans, and also things like 401ks, the defined contribution plans.
Precisely. Those are the main types we think of. But just like welfare plans, there are specific exclusions from the pension plan definition too.
Oh. What kind of things are not considered pension plans?
Well, severance pay arrangements, for one, are generally not pension plans if they meet certain conditions. Like, the payments can't be contingent on retiring, they have to be paid out relatively quickly, and the total amount is limited.
Okay, so severance is usually treated differently.
Usually, yes. Bonus programs are also typically excluded unless they're set up in a way that systematically defers income to retirement.
Right.
Also, certain individual retirement arrangements, like IRAs, where the employer's involvement is very minimal, maybe just payroll deduction, aren't usually ERISA pension plans.
Oh, okay.
And there are specific exclusions for certain payments to pre-1974 retirees and some types of tax-sheltered annuities, 403B plans, under very specific circumstances.
It feels like the distinction between welfare and pension plans really matters under ERISA.
Oh, absolutely. Because pension plans are about long-term retirement security, they face, generally speaking, a much tougher set of rules, especially around funding, making sure the money will be there, and vesting.
Vesting. That's about when an employee actually owns the benefit, earns a non-forfeitable right.
Exactly. How quickly you become entitled to the benefits you've accrued. The rules for pension plans are stricter there.
And where do we find these tougher minimum standards for pension plans in the regulations?
Those are primarily located in Subchapter D of Title 29, which is Part 2530. That part spells out the minimums for participation eligibility, for that vesting schedule we just mentioned, and for how benefits have to accrue over time, all designed to protect that long-term retirement promise.
Okay, Subchapter D, Part 2530. And presumably, pension plans also have to follow the general reporting and disclosure rules from Subchapter C, Part 2520.
Yes, they do. They have to provide SPDs and SARs, file annual reports, and so on. But because they're pension plans, their SPDs need some extra specific information that's detailed in Section 2520.102-.
What kind of extra details are required in a pension plan SPD?
They need to clearly state the plan's normal retirement age. That's key.
When you can get full benefits.
Right. Also, the specific conditions for benefit eligibility, a full description of the benefits themselves, and critically, the procedures for handling QDROs.
QDROs, Qualified Domestic Relations Orders, for divorce situations.
Exactly. The SPD needs to explain how those work under the plan, and it also has to provide information on any joint and survivor annuity options the plan offers, to protect the surviving spouse.
That is a lot more specific detail. What about the financial reporting side? Is the Form 5500, the annual report, more complex for pension plans?
Generally, yes. Pension plans usually file the Form 5500 with several accompanying schedules. These dive deep into the plan's finances, assets, investments, income, expenses, plus its operations and how it's governed. It gives regulators and participants a really detailed look.
Helps ensure the plan is financially sound, hopefully.
That's the goal. Provides transparency into its management.
And I think I saw something about retirement income projections. Is that a requirement now for some plans?
Yes, that's a newer requirement under Section 2520.10053. It applies to individual account plans, like 401ks. Their periodic benefit statements now have to include illustrations.
Illustrations of what?
Basically, projections showing how a participant's current account balance might translate into a monthly income stream during retirement, like an annuity.
Oh, trying to help people think about future income, not just a lump sum.
Exactly, to give them a better feel for whether they're on track for retirement.
Okay, interesting. So we've got welfare plans and pension plans. Now, who's actually minding the store, making sure these plans are run correctly? That brings us to fiduciary responsibility, right?
Yes, absolutely central to ERISA. Fiduciary responsibility. The definition of who is a fiduciary is in 29 CFR, Section 2510.3312.
And what's the gist? Who gets tagged as a fiduciary?
In essence, it's anyone who has discretionary authority or control over managing the plan or its assets.
So decision-making power over the money.
Right. Or anyone who regularly gives investment advice for a fee, but under specific conditions. The advice has to be individualized, the recipient has to reasonably believe it's in their best interest, and the advisor has to acknowledge they're acting as a fiduciary.
Okay, so investment advisors can be fiduciaries too.
Under those conditions, yes. And finally, anyone with discretionary authority or responsibility in the administration of the plan. So it's about discretion and control, whether over assets or administration.
So it's not just a title like plan administrator that makes you a fiduciary. It's about the actual power you wield.
Precisely. Someone just doing routine administrative tasks, purely ministerial functions with no decision-making power, like processing forms based on clear rules, probably isn't a fiduciary.
Yet some roles almost always involve fiduciary duties.
Yes, certain positions like the named plan administrator, a trustee holding the assets, or an appointed investment manager typically carry inherent fiduciary duties because of the nature of their responsibilities.
Okay. And if you are a fiduciary, what are your main duties under ERISA? What does the law demand?
The core duties are spelled out mainly in 29 CFR, Section 20550.404A1. They really boil down to two big ones: a duty of loyalty, a duty of prudence.
Loyalty and prudence. Let's take loyalty first. What does that mean?
Duty of loyalty means fiduciaries have to act solely in the interest of the plan participants and beneficiaries. Their number one goal must be providing benefits and paying only reasonable plan expenses. They absolutely cannot put their own interests or the employer's interests ahead of the participants. Undivided loyalty.
solely in the interest of participants,
Okay.
and the duty of prudence.
Prudence means acting with the care, skill, prudence, and diligence that a knowledgeable person familiar with such matters would use in a similar situation. It's often called the prudent expert standard for those managing investments.
So acting carefully and knowledgeably, does that include diversifying investments?
Yes, diversifying plan investments to minimize the risk of large losses is a key part of prudence, unless it would clearly be imprudent not to diversify in a specific circumstance.
Okay. And fiduciaries have to follow the plan documents.
They do, provided the plan documents are consistent with ERISA itself. If a plan document violates ERISA, following it wouldn't be prudent. And of course, avoiding conflicts of interest is crucial.
How is prudence judged? Is it just about whether an investment does well?
Not necessarily. Courts often focus on the process the fiduciary used to make a decision. Did they do their homework? Did they analyze options? Did they document their reasoning? Regular monitoring is also part of it. Process over outcome, often.
That makes sense. What about newer investment considerations, like ESG factors, environmental, social, governance? Can fiduciaries consider those?
Yes, the regulations address this. While the main focus must be financial returns and risk relevant to providing benefits, fiduciaries are permitted to consider the economic effects of things like climate change or other ESG factors.
But only if.
Only if those factors are relevant to the risk-return analysis of the investment. The bottom line has to be the economic interest of the participants and beneficiaries. It can't be based on non-economic goals.
Okay, so financial relevance is key. And if a plan owns company stock, what about voting shares? Proxy voting?
That's part of managing plan assets, too. Fiduciary responsibility extends to managing shareholder rights prudently. This includes proxy voting. Fiduciaries have to vote those shares solely in the economic interests of the participants and beneficiaries.
Can't use the votes for other agendas.
Correct. Economic interest is the guide.
Now, ERISA also forbids certain kinds of transactions, doesn't it? These prohibited transactions.
Yes, very important area. Part 2550, specifically Section 2550.406, outlines these. They're generally transactions between the plan and people or entities called parties in interest.
Parties in interest. Who does that include?
It's a broad group: the employer sponsoring the plan fiduciaries themselves, service providers, unions involved, relatives of these parties, entities they control, basically anyone with a close connection who could potentially improperly influence the plan.
And what kind of deals are prohibited?
Things like a fiduciary causing the plan to engage in a transaction that benefits the fiduciary personally that's self-dealing, or acting in a transaction on behalf of a party whose interests are adverse to the plan's interests, or receiving kickbacks or personal consideration from someone dealing with the plan.
So it's really about preventing conflicts of interest and self-serving deals that could harm the plan.
Exactly. Imagine the plan hiring a fiduciary's spouse for services at an inflated price. That kind of thing is what these rules aim to stop, ensuring undivided loyalty.
But are there any transactions allowed between the plan and parties in interest? Some seem necessary.
Yes, ERISA recognizes that. So there are statutory and administrative exemptions. These allow certain transactions that would otherwise be prohibited, but only if they meet very specific conditions designed to protect the plan.
Like what? Give me an example.
Okay. A common one is allowing plans to make loans to participants, but there are strict rules about loan amounts, interest rates, repayment terms, and availability to all participants on a reasonably equivalent basis.
So loans are okay if done properly.
Under strict conditions, yes. Another is paying reasonable compensation to a party in interest, like a fiduciary or service provider, for necessary services rendered to the plan. The key is reasonable compensation and necessary service.
Makes sense. You have to pay for services.
Right. And there are also limited exemptions allowing plans to invest in the employer's own stock or real property, but these are subject to significant limitations and diversification requirements, especially for pension plans.
Okay, so exemptions exist, but with guardrails. You mentioned interpretive bulletins earlier. How do they fit in with fiduciary duties?
The Department of Labor issues interpretive bulletins, IBs, to give guidance on how they interpret ERISA provisions. For fiduciaries, things like IB 75-5 and IB 75-8 provide more detail on who qualifies as a fiduciary and how fiduciary duties can be allocated or delegated. They offer helpful clarification.
Good to know those resources exist. Okay, we've covered the rules. Who's responsible? Let's talk enforcement. What happens if someone doesn't follow these ERISA rules? Who enforces it?
The primary enforcer for Title I of ERISA, which covers most of what we've discussed, is the Employee Benefits Security Administration, EBSA, within the Department of Labor.
ABSA again, what's their role in enforcement specifically?
They do several things. They develop and issue the regulations we've been talking about. They provide assistance and education to help plans and participants understand the law. And crucially, they conduct investigations, both civil and criminal, into potential ERISA violations.
To protect participants' benefits.
Exactly. They can bring lawsuits to correct violations and recover plan losses.
And what about penalties? If ABSA finds a violation, what kind of consequences can follow?
ERISA authorizes a range of civil penalties for various violations. These are laid out in Part 2560 of Title 29. The idea is to deter noncompliance.
What kind of violations trigger these penalties?
Oh, things like failing to file the annual report, the Form 5500, on time.
That seemed important.
It is. Also, failing to provide required documents to participants upon request, engaging in prohibited transactions, or breaching fiduciary duties. For pension plans, failing to meet minimum funding standards can also lead to penalties.
Are these penalties fixed amounts?
They're set by statute, but many are subject to periodic adjustments for inflation. These adjustments are detailed in Part 2575.
Ah, so they go up over time.
They generally do. For instance, that failure to file the Form 500, the penalty can be up to 2,063 words per day. It's late, based on the last adjustment mentioned in our source material. That adds up fast.
Wow, per day. That's a strong incentive to file on time. What about for prohibited transactions?
For prohibited transactions, there's typically an initial excise tax or penalty, often 5% of the amount involved in the transaction for each year remains uncorrected.
5%.
But if the transaction isn't corrected within a certain period after notice from the IRS or DOL, that penalty can jump to 100% of the amount involved. So huge consequences for not fixing prohibited deals.
Definitely serious. What's the process like if EBSA decides to assess a penalty? How does that work?
The procedural rules for assessing civil sanctions are mostly in Part 2570 of Title 29. Generally, it starts with EBSA sending a formal notice of intent to assess a penalty.
Okay, a warning shot.
Pretty much. The recipient then usually gets a chance to respond in writing, maybe arguing there was reasonable cause for the failure or that the penalty calculation is wrong.
An opportunity to explain.
Yes. And depending on the type of penalty, the recipient might have the right to request a formal administrative hearing before an administrative law judge, an ALJ, to contest the penalty.
So like a mini trial within the agency?
Sort of, yes. It's also possible for EBSA and the party involved to reach a settlement agreement or a consent order to resolve the matter without going all the way to a hearing.
Okay. And if there is a hearing and the ALJ makes a decision?
There's usually a process to appeal the ALJ's decision, typically by seeking review from the Secretary of Labor. So there are layers of due process built in.
That sounds like a fairly structured enforcement system. So pulling this all together, ERISA seems incredibly comprehensive, just a really critical law affecting almost all private employee benefits in the U.S.
Absolutely. It's truly the bedrock for retirement and welfare benefit security for millions of American workers.
Yeah.
And those regulations in Title 29, Subtitle B, Chapter 65, the eCFR, that's the detailed framework.
And understanding those basic definitions, welfare plan versus pension plan, seems fundamental.
Yeah, because their purposes differ, their specific ERISA requirements differ too. It's a key distinction.
And the whole concept of fiduciary responsibility is just so central, isn't it? Making sure the people in charge act properly.
It is. Those duties of loyalty and prudence are really what safeguard the participants' interests and the plan assets, essential stuff.
Plus, all the reporting and disclosure rules, we talked about the SPD, the SAR, the Form 5500, they're vital for transparency, right? So people know what's going on.
Exactly. Transparency fuels accountability.
Yeah.
It lets participants and regulators see how things are being run.
And the fact that there are real teeth, the enforcement actions by EBSA, the significant penalties, that underscores how seriously compliance needs to be taken.
It does. Without enforcement, the rules wouldn't mean as much. It's crucial for making the system work and ensuring those protections are real.
So really, complying with ERISA isn't just, checking boxes for U.S. employers and plan administrators. It feels like a fundamental responsibility for protecting their employees' financial futures.
That sums it up perfectly. It's about the security and fair administration of benefits that are just so vital to people's lives and well-being.
This has been incredibly helpful, really clarifying a complex topic. Thanks for walking us through it.
My pleasure. Glad to do it.
Now for our final thought today. ERISA, as we've said, is U.S. law, but its core goal, protecting workers' benefits, ensuring retirement security, That's a universal concern, isn't it?
It absolutely is.
So, thinking about the principles we discuss, transparency, fiduciary duty, enforcement, it raises a question for all of us, no matter where we live. What are those truly essential elements needed in any system designed to protect employee benefits and retirement savings? And maybe, what are the biggest challenges countries face in actually delivering those protections effectively in today's globalized world? Definitely some food for thought. Thanks for joining us on the Deep Dive.
Thank you, viewers, for watching. If you found this video helpful, don't forget to hit that like button and share it with your colleagues. And if you haven't already, make sure to subscribe to the channel by clicking that subscribe button below so you never miss out on valuable insights. I'm Brian Edmonds, signing off. See you in the next one.